Hello, and welcome to NCLR's briefing call on the historic Title VII ruling of the Supreme Court. My name is Elizabeth. I'm the Associate Director of Philanthropy here at NCLR, and I will be your host today for our call. I know we have a lot of people tuning in, so we're going to get started, and we'll be able to record this call. So if you are tuning in late, you'll get it all afterwards. A few logistics before we get started. All attendees are in mute. You will see the presenters on the screen, and if you have questions during the presentation, please add them to the Q&A chat at the bottom of your screen, and we'll get those into queue. And I'm really excited to be here with you all today. So we will be hearing from our Executive Director, Imani Rupert-Gordon. We will also be hearing from our legal team, including our Legal Director, Shannon Minter, our Senior Staff Attorney, Amy Whalen, and Senior Staff Attorney and Director of the Trans Youth Project, Asaf Orr. This call, as I mentioned, is being recorded, and we will send it to all participants afterwards. And if you have any technical issues during the call, please reach out to Lexi, who you received the link from this morning. And with that, I'm going to turn it over to Imani.
Good afternoon, everyone, and thank you so much for joining us. My name is Imani Rupert-Gordon. My pronouns are she, her, and hers, and I'm the Executive Director here at the National Center for Lesbian Rights. I'm joined today by some of our amazing attorneys at NCLR, Shannon Minter, Asaf Orr, and Amy Whalen, and they're going to talk to us about what this incredible and unprecedented ruling means for us. But to start off, I wanted to provide a bit of context. So when we're talking about the Title VII decision, we're talking about the Supreme Court's ruling on 3 different cases that came down on Monday. So as a quick reminder, Title VII is part of the Civil Rights Act, and it prohibits employment discrimination, specifically based on a variety of identities, with sex being one of them. So Title VII prohibits employment discrimination on the basis of sex. So it means that you can't refuse to hire, promote, or fire someone for being a man or a woman, or not being a man or a woman. And then the courts have gone further and explained that you also can't make adverse employment actions based on conformity with sex stereotypes. So that means you can't fire a woman who refuses to wear makeup or earrings because that's what you think being a woman means. So given all of this context, this victory really shouldn't be very shocking because it really does make sense. You can't actually describe someone's gender identity or sexual orientation without a mention of gender or sex, which is something that was, in fact, mentioned in the decision. And this is an argument that the LGBTQ community has used in the past, but having this come from the Supreme Court represents a huge victory for LGBTQ people, but for everyone as well, because we're all safer when there are employment protections for everyone. And it matters that this decision was written so plainly. And I'm excited to hear about more about this and why that matters. And I also wanted to take some time to just underscore the importance of this decision and it's happening right now in this current climate. There are people in the streets that are right now demanding structural change, and we're hearing a lot of voices saying that you can't change structures this big. And we want to remember that big changes are possible. And we're seeing that represented right now. The people that are in the streets that have said that this is their identity, this is who they are, they were represented in this decision, and that's really exciting. The last thought I want to share with you is the impact that this will have. So this decision is specifically about employment, but it's certainly going to have huge implications when we consider other discrimination laws, how we interpret rules like the heinous one that came out last Friday that was attempting to keep trans folks from accessing healthcare, and when we're considering people that don't come from places that have state protections, which is huge because 28 states don't have employment protections for LGBTQ people. So this decision is going to have a huge impact on where we can go and what's going to protect our community moving forward. And so lastly, before I turn it over to our amazing team, I want to give folks just a quick breakdown of the 3 cases we're looking at. The first case has to do with gender identity. Amy Stevens worked as a funeral director, and for most of her employment at the funeral home, she lived and presented as a man. Shortly after she started presenting as herself as a woman at work, she was fired, and the Supreme Court on Monday determined that her identity as a transgender woman was protected by Title VII, the Civil Rights Act, under sex discrimination. Then the other 2 cases both have to do with sexual orientation. In the second case, Gerald Bostock was the head of a child welfare program. He was considered a good employee, received awards, and had favorable performance reviews. And then after he joined a gay softball league, he was fired for conduct unbecoming a county employee. And then the final case was with Donald Zarda. Donald was a skydiving instructor, and he told a female client that he was gay in an effort to assuage her concern about being strapped together when they would go on a tandem jump together. He was fired for sharing inappropriate information about his private life with customers. So on Monday, the court made a determination that discrimination on sexual orientation was in fact discrimination based on sex and should be covered by Title VII protections, which is huge. So those are the cases we're talking about when we talk about the Title VII cases. So now that you have a bit of context, you'll hear about what this is going to mean for our community, where we can go from here, and what we think is going to happen next. We also know that this isn't a cure-all. This is, there are some things that Title VII doesn't do, and we're going to talk about that as well. So thanks for joining us, and let's get started. Shannon, why don't you start us off?
Okay. Hi, everybody. Yeah, I'm Shannon. I'm the legal director. I use he, him, and his for pronouns, transgender guy. So, we've been, of course, like everyone, waiting for this decision for a long time, and trying to think ahead and plan about different possible outcomes and what we would say. And I will tell you that when we were planning for that, I thought there was a very good chance that we would be here with you all today and in similar discussions, discussing either a loss or, maybe a partial win or an ambiguous win that held that, well, LGBT workers have some protections under Title VII, but not full protections. But just to be perfectly honest, I will confess that never in my wildest dreams did I think I would be here discussing a 6-3 opinion authored by Justice Gorsuch, one of the most conservative justices on the court, and joined by Chief Justice Roberts, also pretty conservative justice, holding that, quote, an employer who fires an individual merely for being gay or transgender defies the law. That's pretty direct and pretty darn comprehensive. The decision the Supreme Court issued on Monday, as Amani just explained, under Title VII, part of the Civil Rights Act of 1964, that prohibits sex discrimination in the workplace, they could not have been more clear that Title VII fully and completely protects LGBT people. And that means that for the very first time ever in our nation's history, every single LGBTQ person in this country now has workplace protections. Every single LGBTQ person who's fired or not hired or discriminated against in some other way on the job now has the right, affirmed by the U.S. Supreme Court, to go to federal court and file a federal sex discrimination claim. So that's pretty astonishing. I'll say a little bit of humor here. I'm not the only one to be surprised by this decision. I was reading the paper this morning, and the headline of the leading editorial in the Wall Street Journal, this is what it read, literally. This is a direct quote. An alien legal being seems to have captured Justice Gorsuch. And then the next sentence of this op-ed, it says, an alien appears to have occupied the body of Justice Neil Gorsuch as he wrote Monday's opinion in Bostock versus Clayton County. So the Wall Street Journal's not too happy with Justice Gorsuch right now. And they're kidding, of course, but at least I think they are. But a lot of people have noted it is pretty remarkable that a justice as conservative as he is authored such an amazing opinion. And I think, to me, that really underscores something we should not forget in all the battles that we have now, which is that most people in this country do strongly support anti-discrimination protections for our community. I mean, we've got super majorities now. When you do look at the polling data, people are strongly with us on the basic fairness, anti-discrimination. We've seen that in the transgender military ban litigation, where I think as a result of the increased visibility of transgender service members, as a result of that case, we've got polls show we have more than 70% of the public across political lines opposes the ban and supports transgender service members. So that's pretty extraordinary. And I mean, this in the literal change in the law that this decision affected is huge. I mean, it's enormous. You know, as Amani said, there's fewer than half the states have any, like a shred of anti-discrimination protection for LGBT people. So like a huge, more than half our country just went from having no protections to having at least full workplace protections under federal law. So pretty remarkable. Um, you know, the other I just wanted to hit on, and Amani just covered it beautifully, like the scenarios, like the facts in these cases, exactly the ones that we've seen. I've been at NCLR 27 years, litigating these kind of cases for 27 years. What we see with discrimination against our community, in contrast to some other communities where employers have learned to try to mask it or to be more subtle, no. When it comes to like LGBT workers, as you saw in these cases, they're just like, oh, Gerald Bostock, you're gay. Okay, you're fired. You know, Donald Zarda, oh, we know you're gay now. You're fired. Amy Stevens, you've come out as a transgender woman. Sorry, that's just not going to work out for you at this workplace. So there's nothing subtle about it. And the issues in the case were not about the facts. Nobody was disputing, did we really discriminate because the person was gay or transgender? That was agreed upon by everyone. It was just a legal question. Is that sex discrimination? That was the question for the court. I'll just say, like, for many years now, legal advocates, myself included, have been making the case that, yeah, heck yeah, it's sex discrimination. And that's especially true for transgender people. Like, I remember going to legal conferences back in the 1990s organized by Phyllis Fry in Texas. She was an openly transgender attorney. She was the first openly transgender judge to be put on a bench anywhere in the whole country. That happened in Texas. But she used to put on these employment law conferences, start going way back to the 90s. And I remember vividly sitting through panel after panel, year after year, with people making the strong argument that, yeah, discrimination against transgender people, of course, is sex discrimination. And I've seen courts become more receptive to that argument over the years. So by the time we got up to the Supreme Court, they weren't doing something really big and bold and radical. Like, there was a really huge, actually by that point, and pretty close to unanimous body of federal case law saying, yep, discrimination against transgender people, that is sex discrimination. Now, we were making similar arguments about sexual orientation, but they hadn't gotten as much traction in the lower courts. We made those arguments all through the marriage cases, of course, to say that if Bob can marry Jane, but he can't marry Bill, what is, the only thing different there is the people's sex, and that's sex discrimination. So I think we, in the Supreme Court, heard those arguments in Obergefell. They didn't rely on them or adopt them, but I think they've been kind of softened up to be receptive to recognizing, yeah, sexual orientation discrimination is sex discrimination too. I'll just say, like, also that I think it helped that in the lower federal court cases, it wasn't just the super liberal or progressive judges that were accepting those arguments. In fact, oftentimes it was very conservative judges who had agreed that this is sex discrimination. But anyhow, there's a lot packed into the opinion, the majority opinion authored by Justice Gorsuch. It's like this very, someone referred to it as nitpicky, almost like just really focus on the meaning of the plain text of the statute. So I'm not gonna, get into all that, but when you read the decision, that's what you expect that. Do not expect the kind of flowery, almost poetic rhetoric and language that we used to get from Justice Kennedy when he wrote his pro-LGBT decisions. There is not a shred of that in this decision, with one exception that I'll get to in a moment. But basically, they just said, look, it's impossible to discriminate against a person for being gay or transgender without discriminating against them based on their sex. You can't even identify a person as being gay or transgender without talking about their sex, and that gets you all the way for a Title VII claim. I will say, I want to go back to the point about this being a very dry opinion that doesn't have a lot of, it doesn't really even say discrimination is bad, doesn't talk about the history of discrimination against LGBT people. It just focuses just very technically on the language of the statute. But there is one exception, and it's really important. And it's the paragraph where the court talks about Amy Stevens, the transgender plaintiff in the case. And I'll just say that if you go read that paragraph, and you'll see what I mean, but it expresses enormous warmth, compassion, empathy, understanding for what it means for a person to be transgender, the pain of trying to go through a gender transition, knowing that you're going to meet with a lot of rejection. And real importantly, it unambiguously refers to Amy with no hesitation, no hedging, no kind of any of that, as female, as a woman. Which is really important. It sets a great example for our country. It sets a very clear example for lower courts. And that means a lot right now, because one of the many things that the Trump administration has been trying to do is to create this new narrative that people shouldn't have to refer to transgender people using their correct names or pronouns, and that somehow that's violating their free speech. And I think Asaf is going to talk about a case we're litigating that involves that now. So to have the U.S. Supreme Court be so clear and not even clearly, they didn't even consider referring to Amy as anything other than female, really is one of the most powerful and important aspects of this decision. And I'm really hoping it shuts down that attempt by the current president to re-stigmatize and transgender people and kind of throw our whole authenticity into question. I hope the decision money really puts a stop to that. Last thing I want to say is, this was Title VII. It was one statute about federal sex discrimination, but as Justice Alito noted in his dissent, there are more than 100 federal laws that in some way touch on, prohibit sex discrimination in various arenas. The decision the logic, the analysis in the decision is going to apply to every single one of those. So we want a lot more money than just workplace protections. Of course, this isn't going to execute itself. We're going to still, as long as Trump's in office, we're going to have to litigate every square inch of this, and we will, and we are. But we're going to do so knowing that the Supreme Court just gave us a huge boost and basically made it clear that any federal law that prohibits sex discrimination also protects LGBTQ people. With that, I'm going to kick it over to Asaf to talk about an important example of this, which is Title IX in sex discrimination protections in schools.
Thanks, Shannon. Good afternoon, everybody. So as Shannon indicated, I'm going to talk about Title IX, but before I jump into it, I just want to sort of lay the foundation. As Imani talked about, in the work context, in the employment context, there are about 28 states in which you could get fired for being LGBT. In the school context, there are only 14 states that include protections for LGBT students. So, the fact that we now have a ruling that from the US Supreme Court interpreting sex discrimination to include LGBT people means that there are so many students now when they return to school, hopefully in this coming school year, that they'll have protections that they didn't have when they left. So what is Title IX? Title IX is a federal law that basically says any educational institution that receives federal funds cannot discriminate on the basis of sex. And although, again, Bostock was about Title VII, courts want consistency across federal law. So if, they want sex discrimination to mean the same thing in similar statutes. And in fact, courts look very heavily to Title VII to interpret Title IX. And so, again, even though it was a different statute, this is going to have a really significant effect on how courts interpret Title IX in the future. And certainly, I think the analysis is very much the same. And so we can easily say that LGBT students are covered under Title IX. But what does that mean then for the students as they return to school? One of the biggest things that we often hear about is bullying and harassment, either by school staff or by students. It was a huge open question until Monday about whether or not LGBT kids would be covered from bullying and harassment on the basis of sexual orientation in particular, but also gender identity. Well, that issue has been resolved. So now when kids go back to school, if they are subjected to mistreatment, that is certainly something that they can raise with their schools, and ultimately, if it becomes severe enough, possibly sue their schools for the harm that it causes. But also one of the things that comes out from Bostock then is that any policies that discriminate against LGBT students also violates Title IX. We see this a lot in the context of trans students regarding access to sex-separated facilities and activities. By that I mean restrooms, locker rooms, sports. The Supreme Court was clear to kind of accept those out of its ruling. But again, the logic is the same. You know, when you have, for example, a policy that denies transgender students access to the correct facilities based on gender identity, you're in fact having a separate rule for transgender students because of their gender identity, that you're allowing non-transgender students to use the facilities consistent with their gender identity, but not transgender students. And so from an analytical perspective, it's the same. So I think, you know, there's going to be a lot of, you know, and this is also all consistent with, as, you know, Shannon indicated, courts have consistently held this way in support of LGBT students. And now they're going to be further bolstered to do so. One of the other things that I wanted to address in terms of the effect of Bostock, in addition to, you know, clarifying that Title IX does cover LGBT students, it also is going to have an effect on the many things that the Trump administration has done, or through Betsy DeVos as the Secretary of Education. Many of you may have heard of the various guidance documents that they've issued that have rescinded Obama-era guidance documents regarding the rights of transgender students in schools, as well as more recently finding that the Connecticut Interscholastic Athletic Coalition or Committee's trans-inclusive sports policy violates Title IX. All of those decisions and all those guidance documents are based on an incorrect or a very limited scope of what it means to constitute sex discrimination, which the Supreme Court flatly rejected in Bostock. So it calls into question the ongoing validity of those guidance documents and of the letter of findings in the sports case. Now, that's not to say that the DeVos administration or the DeVos Department of Education is not going to continue to make those arguments, but they'll have to do a lot of legal acrobatics to kind of still make it work given the Bostock decision, and would certainly have a very hard time withdrawing federal funds from any school district that had a trans-inclusive policy. The last thing I wanted to touch on is kind of what's on the horizon. And, you know, Alito's dissent goes through the sort of the parade of horribles. And one of the things that is mentioned is this idea that, you know, people are going to be exposed to liability because they misgender a transgender student or a transgender person. And also talking about sort of what does this mean in terms of interaction with free speech rights, as well as the right to free exercise of religion. Well, those cases are already here. We are currently representing Jane Doe and the LGBT student group at Shawnee State University in a case where one of the professors at the university was disciplined for refusing to use the correct pronouns and honorifics when referring to our client in class. And he's claiming that his refusal or being disciplined for refusing to use those pronouns violates his First Amendment right to free speech, as well as his First Amendment right to the free exercise of religion. We were successful in getting that case dismissed by the trial court, and the trial court very easily held that his free speech rights were not violated, neither was his free exercise rights violated by the school's policy, anti-discrimination policy. Now, this decision in Bostock further bolsters the fact that Shawnee State University has a really good reason for having this policy and enforcing it in the way that they did. That case is now on appeal before the Sixth Circuit Court of Appeals, which covers Ohio, Michigan, Tennessee, and Kentucky. Although those four states tend to be quite conservative, that is the same Court of Appeals that ruled in favor of Amy Stevens, In the case, it was just decided on Monday. And they have a really long track record of supporting transgender employees and also finding that sex discrimination includes transgender people. So we're hopeful that the courts will continue to recognize that the right to free speech and the right to free exercise of religion do not undermine general anti-discrimination protections for LGBT people, both in the school context and elsewhere. And with that, I will turn it over to Amy. Thanks so much.
Great, thanks everybody. Hi, I'm Amy Whalen. I'm a senior staff attorney here at NCLR. I am going to address, and I know some people submitted questions about this too. I'm going to address really briefly, and I'm going to use two NCLR cases as examples, how this amazing Title VII decision that was issued this week by the US Supreme Court could impact LGBTQ people in both the housing context and also the healthcare context. And so, and the quick answer, spoiler, is it's amazing. And I think it's gonna be great. So I'm just gonna talk really briefly about two cases that we've had that just kind of hopefully will illustrate this impact for folks. One is a current case that we actually have pending right now, but that was put on hold while we were awaiting this Title VII decision from the US Supreme Court. That case is called Walsh versus Friendship Village. We represent Mary Walsh and her wife, Bev. They are an older lesbian couple who were applying to live in an assisted living facility, Friendship Village. They put their house on the market. They were very far along in the process of getting a housing unit at this assisted living facility when they got a call one day from the director of the facility saying, I'm so sorry I'm calling you, but I need to understand exactly what your relationship is. And Mary, who took the call, said, well, we are married. We've been married since 2009. And the woman said, I'm gonna have to call you back. And soon thereafter, Mary and Bev were told that they are not welcome at Friendship Village as a same-sex couple. It turned out that the facility thought that they were sisters applying to live together. And when they found out that they were a married couple, they told them, sorry, we don't want you here. We filed a lawsuit on their behalf in 2018, July of 2018, and we lost this case in the district court. And the reason that we lost this case, I just went back, in fact, today to go and look at the decision, is because the district court judge looked at Title VII cases in the circuit where this case is. It's in Missouri, so was looking at 8th Circuit precedent. And the district court judge said, well, here in the 8th Circuit, we have a case that says that Title VII, which protects people from sex discrimination in employment, does not cover gay people. And so I am bound by that opinion. And that was kind of the primary main basis for her deciding that Mary and Bev's suit should be dismissed. We appealed that decision to the 8th Circuit, and that is where the case was pending before it was stayed and put on hold awaiting this Title VII decision. So the truth is that federal courts look to other federal laws to interpret how they might apply. The Fair Housing Act itself is actually part of the Civil Rights Act of 1968, just as Title VII is. It was enacted as part of that law. It prohibits discrimination when people buy or rent a home, when they get a mortgage, when they're seeking housing assistance, or when they are engaged in other housing related activities. And it prohibits discrimination like Title VII based on sex. So there's no reason to believe or think that federal courts should be interpreting that law any differently from how the US Supreme Court just did with Title VII. The other context I want to talk about really briefly is the healthcare context. So some people might not even know this about the Affordable Care Act, but there is a non-discrimination provision in the Affordable Care Act that prohibits discrimination based on sex. So a couple of years ago, we filed suit on behalf of the mom of a transgender kid here in California, in part based on the Affordable Care Act. We actually, because he lived in California, we were able to include state law claims as well at that time. But one of our main causes of action was that he was discriminated against in the healthcare setting under the ACA based on sex. He was a kid who needed inpatient psychiatric care for a crisis that he was experiencing. He went to a hospital in San Diego, which is the largest children's hospital in the state and in that county. And the staff in the hospital repeatedly misgendered him and discriminated against him as a transgender kid, despite the fact that his mom had been advocating and was very clear about his severe gender dysphoria and how important it was to make sure that they didn't discriminate against him. So we actually represented the mom in that case because at the point that we filed it, very tragically, her son had died by suicide. And so ultimately we were able to settle that case on behalf of the mom. But before we did that, we got a ruling, and this was back, I think, in 2017 from the district court in California saying that discrimination against a transgender kid is sex discrimination under the Affordable Care Act's sex discrimination provision, and allowing our case to move forward on that claim because the court interpreted it as sex discrimination. So I want to just talk about two things because I think people are wondering about this. One is, what effect does this Title VII decision that the Supreme Court issued have on HHS's recent anti-trans regulation that it issued interpreting the ACA? So that regulations tend to be important to give guidance to folks in terms of what policies and procedures that they should be following. But when you bring a lawsuit on behalf of someone, you sue based on the statute. So when we brought the lawsuit on behalf of Kyler Prescott, we sued based on the actual Affordable Care Act, not the regulation. So that is not a basis for your claim. Sometimes it can be helpful, though, to show the court what their reasoning also should be in interpreting that statute. And so in our Prescott case, in fact, the district court talked about how our claim was based not on the HHS regulation that was in place at that time, but instead on the statute itself. And then the court looked to Title IX claims and cases and Title VII claims and cases to rule that, similar to rulings in under Title IX, which is the law that Asaf just talked about, related to schools, and also Title VII in employment, that we had stated a claim for sex discrimination under the Affordable Care Act because discrimination against transgender kids is sex discrimination under that law. And so this is, I think that for people who are wondering what might be the impact for healthcare and for housing and for other federal laws that protect against sex discrimination, the news is going to be really good. And for our housing case that's alive right now, we're figuring out how to jumpstart that case and move forward and hopefully get Mary and Bev the relief that they deserve. Shannon, did you want to take over from here?
Oh, well, I think we should turn to questions now. Yeah, I just want to underscore what Amy and Asaf just said. In every significant area of federal law, we are now in a great position to continue the cases we've already got in the pipeline, but on a much firmer footing, and to we will be very aggressive about bringing new cases under this sex discrimination theory. I mean, NCLR has been invested in the sex discrimination theory and been at the forefront of, promoting that and trying to get courts to accept it for literally decades now. And Asaf brought the very first case under Title IX promoting that theory for a transgender student that was successful and that ended up laying the foundation for the Obama administration's wonderful education guidance for schools, saying, hey, you have to protect transgender students. I mean, long story short, the Obama-Biden administration paid attention to what the federal courts were doing. They recognized that federal law was evolving to a place, and it was pretty firmly established, particularly for transgender people, that discrimination against us is sex discrimination. And they systematically went through and updated all of the relevant federal rules and regulations and policies to reflect the law, to protect our community. And what's happened since President Trump was elected, that has systematically been undone. They just one by one have chopped away rule after rule, undermined every protection that was put into place. And we've been saying, the whole movement has been saying, hey, you are violating the law. Like, by the law, we are protected under federal sex discrimination statutes. And the Trump administration has been saying, no, we don't think so. And we don't think the Supreme Court will agree with you. Well, guess what? They just did. They just did. One of the very justices that Trump has been patting himself on the back about putting on the court agreed with us that sex discrimination law does protect LGBTQ people. So that's like the big picture shift in where we are now. It's the same thing we've been saying all along. We've been promoting these cases all along and bringing these cases and largely winning these cases, but we've met the big giant roadblock of a president that has been intent upon re-stigmatizing our community. And the Supreme Court just, again, somewhat to my surprise, honestly, stood up and said, no, we're not going with you down this path of scapegoating a vulnerable minority. And we're not going to twist the law around and pretend that discriminating against someone because they're gay, i.e. have same-sex partner, or because they're transgender, i.e. have a gender identity different than their birth sex, that's not sex discrimination. Plainly it is. And that's what they, I have to give it to them, that decision for Monday has a lot of integrity. I feel a new level of hopefulness that I have not felt in some time, since this administration got into office. So anyway, but yeah, Elizabeth, we should take people's questions.
Great. Thank you so much, everyone, for your presentations. That was wonderful. And some of the questions actually were answered during your presentation, so I'm going to try to filter these through now. The first question I have is, what is the impact in states that do not have non-discrimination laws?
Well, now they do. It's states in states that are already, like California for one, but there's lots of them, of course, 22, 23, depending on how you count, have state laws. So that's great. Those are still in the books. But even in those states, it means that people also have federal protections. And as Amy would be the first in line to say, most employment attorneys, plaintiff side employment attorneys, would generally rather be in federal court. The protections are stronger, the remedies are stronger, the courts are more generally adept at dealing with those claims. So it's a huge improvement and benefit no matter where you live. But the biggest benefit is for people who live in states that do not have any state protections at all, which is more than half the states. And now every person in those states does have the incredible power of being protected under federal sex discrimination law. That is a really big deal. They can go file a complaint with the Equal Opportunity Employment Commission. You don't have to have a lawyer. It's better if you do, but you don't have to have one. Or you can get a lawyer and file a case in federal court. So people, went from not having any secure protections last week to, as of Monday, every single LGBTQ person in this country does now have clear, strong protection against workplace discrimination under Title VII.
Thank you, Shannon. One of the questions that we had submitted during the call is, What is the active case regarding using correct pronouns that Shannon referred to? Shannon, can you talk to us a little bit about that one?
Well, stop. Did you want to talk about you
Yeah.
did mention it, yeah.
Yeah, so the name of that case is Merriweather versus Shawnee State University. It is one of 3 cases that are currently pending in the United States. The Alliance Defending Freedom, and a rapidly anti-LGBT legal group, is representing Professor Merriweather in that case. They also filed another case in Virginia on behalf of a teacher who was fired for refusing to use the correct pronouns when referring to a student in his high school student in his French class. That case is currently pending in the Eastern District of Virginia, the federal trial court in Richmond. We are representing the transgender student in that case as well. And there's a third case in Indiana in which the court, much like the court in Ohio in Merriweather, rejected claims that teachers' First Amendment rights were violated by a school, insisting that the teacher comply with the school's anti-discrimination policy. So Merriweather is sort of the one that's kind of furthest along, if you will, in terms of being on appeal, closest to the Supreme Court. But there are a number of cases, and I'm sure after Monday's decision that we're going to start to see more of those cases and in different permutations of those cases.
Thank you, Asaf. The next question I have is, what types of employers and employees are impacted by the Title VII ruling?
Amy, do you want to answer that?
Yeah, and I just saw a question about this also in the chat. But yes, generally Title VII applies to employers who have at least 15 employees, including contract employees or remote employees. So there's a variety of ways to get what seem like smaller employees covered by this if they have remote or contract employees as well. But as a general rule, it applies to employers who have at least 15 employees. So some of the most tiny, smallest employers could be excluded, although there are other laws that might apply to them that don't have those limitations, like the Equal Pay Act or state laws as well. So it's always, of course, essential for people to contact attorneys if they think that they've suffered discrimination so that they can be advised about what laws might apply to their claims.
Thanks, Amy. The next question I have is, do you expect incoming litigation regarding Department of Education's trans-exclusive guidance policies?
You know, that's a great question. I think that given the ruling in Bostock, you know, there's going to be cases around what it means to discriminate in schools in the context of harassment and access to facilities and things like that. But actually, a lot of those questions have already been answered by the federal courts, including the Supreme Court. There was a case out of Pennsylvania where non-transgender students challenged a school district's trans-inclusive policy that allowed transgender students to access the correct facilities, restrooms and locker rooms based on gender identity. And those plaintiffs lost at both the trial level and the Third Circuit Court of Appeals. And they asked the Supreme Court to take up their case and to decide this issue nationally, and the Supreme Court declined. And so, you know, there are already cases kind of in the works. Also, you know, you may remember the Gavin Grimm case from a number of years ago. Most recently, the trial court once again held that the school district discriminated against Gavin Grimm by denying him or excluding him from the boys' restroom. That case is also now on appeal again to the Fourth Circuit Court of Appeals. So we are going to see cases come up, and those rulings, in addition to Bostock, will, you know, further limit the sort of applicability or validity of those those guidance documents. I don't know that there's going to be a direct challenge to them, but even after Monday's ruling, it would be very hard for the Department of Education to try and enforce them.
Thank you, Asaf. Okay, the next question we have is, in terms of equity, what do you all see as the next steps on bridging the existing gap of rights of trans people of color? This is a blunt instrument, but we have to recognize that Black and brown people have not enjoyed the full rights declared in the Civil Rights Act of 1964.
Yeah, well, there's a lot of things. One of our goals as an organization, and I want to give a shout out to my colleague Tyrone Hanley in DC because he's really spearheaded this, is to get us to rethink what we consider to automatically count as an LGBTQ issue, and to recognize that issues that we may not ordinarily identify as LGBTQ issues are very much central to our movement, should be central to our movement, and affects people in our community in such a profound and pervasive way that they should be at the forefront of what is on our LGBTQ rights agenda. And those include racist police violence. And of course, for Black and brown LGBTQ people, they're at the just merciless intersection of facing transphobia, homophobia, layered over with race, sexism, and that is often a very violent and lethal place to be, especially when we're talking about police, the incredible levels of violence and just daily harassment and mistreatment that people of color and Black and brown people in particular undergo in this country, and it's just magnified for people in our community. So that's one issue, but others too. We need to get serious about supporting efforts to decriminalize sex work, because it puts so many people in our community in such incredibly vulnerable positions economically, and vulnerable to violence and to police harassment, food insecurity, housing insecurity, economic precarity, and people in our community. Levels of poverty and underemployment and unemployment in our community are through the roof. And every single one of those is most extreme and pronounced among LGBTQ people of color. So these are our issues. These are not other people's issues that we need to care about. These are issues that are directly and centrally affecting our community and that we need to elevate in our agenda and work. And we are working very actively. I don't know if anybody else wants to jump in there, Monty or anybody else.
I guess I'll add, I know that we're also working on the legislative front to undo some of the bad decisions that have really gutted protections under Title VII or other anti-discrimination laws that would have been very helpful in addressing systemic racism in our country. For example, in terms of how courts analyze race discrimination cases where both the employee and the supervisor or the employer are people of color, whether or not folks can bring disparate impact cases under particular statutes. So there's a lot in there, and NCLR is working on all those fronts, either directly or supporting organizations who's sort of are leading the effort to undo those bad court decisions.
Thanks, everyone. We have a few more questions. The next one is, with this ruling, do you believe a transgender person could win a congressional seat in Congress?
Yes. Yes. I mean, I think we're already moving toward the direction of much greater acceptance and support and visibility. And we've had some wonderful wins with openly transgender people being elected to state legislatures. And you betcha, I think that is entirely going to happen in our future.
Excellent. Next question is, okay, let's see. My question is broader than the impact of the law. Do you think this decision, like the marriage decision, will be the catalyst for a sea change in public opinion?
I think absolutely. I mean, you know, as we saw with the marriage equality cases, obviously it's really significant legal effect for cases like Bostock, but certainly, as people see that LGBT people are covered and treated with respect and equally under federal law, it certainly does have an effect because people start to recognize that LGBT people are their equals and are entitled to the same respect and dignity that everyone deserves. How long that will take, that is anybody's guess, but it's certainly, we even saw some of that happen after, the Obama guidance, for example, in schools back in 2016. There was already a sea change that happened as a result of that. That has never, never fully receded, even under all of the Trump administration's attacks. And I fully expect so we'll see that same effect happen after this decision and into the future.
Thank you, Asaf. Amy, did you want to say anything about that? You good?
I was just going to say, I actually think that our government as a general rule is far behind public opinion, and that they don't actually make rulings until there's already kind of a sea change in the public opinion. And I think that was kind of true about marriage, and it's also true here in the employment context, that there are many, and at the same time that there's still extreme discrimination against LGBT employees around the country, there's also been amazing progress by Fortune 500 companies and other groups that have led the way and decided on their own to have anti-discrimination business policies, pretty regularly and consistently, that expressly protect people based on sexual orientation and gender identity. And so I actually think that we are the leaders of this, that the public is already largely with the LGBT community, and the fact that the US Supreme Court issued this decision shows that that opinion is a majority opinion in this country, which is, a good place to be for our movement, even though there is so much work to be done on all of the issues that people have been identifying.
Thank you for that. We have several questions, and I know that we're coming up to the top of the hour, so if everyone's okay with it, I'm just going to keep rolling through the questions. The next one we have is, the ruling names gay and transgender workers. What are do the implications apply to all LGBTQ people?
Well, I think that the ruling applies to all LGBTQ people to the extent that they're fired or harassed or experience discrimination at work based on the fact that they are gay or transgender, or the fact that they might adhere to some stereotype about sex that their employer doesn't agree with. So it definitely does extend, but it's based on sex discrimination. And so the underlying discrimination has to be based on that category.
And I would just add, as long as those LGBT folks are covered under federal sex discrimination laws, whether it's in employment or housing or schools, that the reasoning of Bostock would certainly apply outside the employment context as well. But again, it would have to be a situation that's covered by federal anti-discrimination laws.
Thank you. And the next question I think we touched on, but I'm just going to ask it again. Does the federal law stick to the 15 employee threshold?
Yep, we did get to that, and generally it does, but there are ways around it sometimes. And so do not be deterred in calling a lawyer if you think that your employer might be too small, because there are creative ways to get around that.
Thanks, Amy. The next question we have is, what can low-income LGBTQ people do now to protect themselves when they are being discriminated against in programs and services covered under a federal sex discrimination law?
I mean, one answer is they can call NCLR. We have a national helpline. We field hundreds of calls every year about employment issues and also any other issue that LGBTQ people face around the country. So that's one answer. We also have this partnership that we do of training legal aid attorneys around the country. And so legal aid offices focus on legal services for low-income folks. And we have a partnership with a network of legal aid attorneys all around the country where we provide training about issues related to LGBTQ people. And so sometimes those offices can also provide support and legal assistance for folks. So there are a lot of resources. The one good thing also about these laws is that they have attorney fee provisions. And so you can get private lawyers as well sometimes to represent you in cases where you wouldn't otherwise be able to afford them, because if you win, the lawyers can get paid from the defendant, from the discriminator in the case. And so, that's another reason why federal law is really helpful in this context, because they have fee provisions which in turn allow private attorneys to also bring cases on behalf of people who wouldn't otherwise maybe be able to pay for legal help.
Thank you, Amy. The next question I have is, are religious employers exempted from this? What about religious institutions like Catholic churches, religious schools, etc.?
Asaf, I don't want to hog it, but I'm happy to, if you want me to take a stab first.
Go ahead and I'll follow up if you miss anything.
Okay. This is a great question. And I think that this is one place where there is going to be a lot of litigation about issues. But Title VII itself, some laws have religious exemptions for religious entities. And so in other words, if you are a religious entity, the law doesn't apply to you at all, that you can be exempt from that. Title VII is not one of those laws. Title VII allows for some religious accommodation for religious employers who want to employ people of a particular faith. So in other words, maybe you have a Catholic employer and they want to employ only Catholic employees. There's some protection under Title VII for that, but there is not a general religious exemption for all Catholic employers or all religious employers under Title VII. And so that's good. And it means that generally, for generally applicable laws that are intended to protect people from discrimination that our country views as abhorrent, then they are bound by those laws unless there's some good reason. There's one other complicated issue with some employees who are considered ministers by a religious employer, and that is a more complicated issue. And sometimes they could also be exempt from generally applicable discrimination laws related to those employees. But as a general matter, Title VII would also protect discrimination for people who work for religious employers.
I think the only thing I would add to that very briefly is that unfortunately Title IX is one of those statutes that has quite a broad religious exemption. And we have seen educational institutions seek specific permission from the Office for Civil Rights, which is what they're required to do under Title IX, to get those exemptions. And they've gotten exemptions, things ranging from not an exemption from requiring to treat transgender students consistent with their gender identity in terms of housing, to requiring female students to have specific additional graduation requirements that they felt were necessary to prepare them for life outside of college.
If I can just jump in really quick, I do like to leave these to the attorneys, but it was really clear that they weren't actually talking about religion too, and I think that that's important, that they talked about this decision specifically not being around religion, and so just so folks know, I do think that that's something that we're gonna see in the future.
Okay, so the next question we have is, in terms of state legislative threats, we're seeing a major trend of trans high school athletes being under attack recently. How do you think this decision will affect this policy push by the far right? Asaf, do you want to take that?
Sure. I think, you know, we're seeing a very large coordinated effort to introduce and get anti-trans legislation passed in states all across the country. As the question noted, certainly in the sports context, but in other contexts as well. For example, criminalizing healthcare providers for prescribing transition-related care. You know, I think what this ruling does is demonstrate that those legislative efforts would be met with very strong litigation opposition, and that the claims that those laws are either unconstitutional or violate other federal laws is quite strong, and hopefully that will deter state legislatures from passing these bills, because as Amy noted, you know, if there is a lawsuit and it is successful, they ultimately have to pay attorney's fees, which, you know, in these cases can get quite high, and is certainly a deterrent, especially in times like these where state budgets are uncertain given COVID-19. Hopefully legislatures will be a little bit more judicious when they are considering bills that target and harm LGBT people.
Thank you, Asaf. Okay, I'm going to try to move through the rest of these questions. Does this protect LGBTQ minors that are in the workplace?
Assuming that they're not violating labor laws by being in the workplace, it would definitely protect LGBTQ minors if they were discriminated against based on their sexual orientation or their gender identity. There's no exclusion for minors related to employment discrimination laws. So yes, they would, and that's also great.
Thanks, Amy. There's a comment in here I want to read. It says, I think it's important to answer whether bisexual, pansexual, and non-binary people are also included here.
That is a resounding yes. I think, you know, although the cases themselves, because of the plaintiffs involved, you know, Justice Gorsuch's opinion really focused on gay and trans folks. Really what the opinion was talking about is sexual orientation and gender identity. And so to the extent that a non-binary person or a pansexual person is discriminated against based on that sexual orientation or gender identity, that too would violate federal sex discrimination laws.
Thank you, Asaf. That leads me into the next question, which is, what do we say to people who are now going to say Gorsuch isn't so bad after all?
Well, you know, I mean, I don't think there's any denying that this is a momentous decision for the LGBTQ community, and that, you know, many of the nuances that we thought might be included in this decision and we were trying to prepare for and anticipate and figure out how we would deal with are not in there. Like Shannon said at the beginning, it's super clear and clear cut. And it basically says if you discriminate against gay or transgender people, that violates federal law. So, you know, what related to this issue, I think that this is a great decision. There are many other decisions pending that Justice Gorsuch is extremely conservative about and could issue very damaging and disturbing opinions about. And so I think that we shouldn't lose sight of the fact that there are many other civil rights cases coming down the pike that will deeply affect the LGBT community. There's abortion cases, there are cases about immigration, there are cases about qualified immunity as it relates to police violence. So and that's just to name a few. There are cases about the ministerial exception that I mentioned before. And so I think there are many, many ways still in which this court could issue decisions that are horrible and really terrible, not just for our community specifically, but for every community that relies on, you know, protections that a democratic civil society provides.
Great, thank you, Amy. Okay, I have two more questions. The first is the ERA needed as an additional legislative work to support anti-discrimination laws?
I think that's a great question. Certainly, we would say that the Equality Act, which is currently pending in the Senate, as it already passed the House, which would amend federal anti-discrimination laws to explicitly include LGBT people within the scope of those laws, it would certainly be a huge step forward, just to clarify, or further enshrine the reality that LGBT people are covered under federal anti-discrimination law. I think that to the extent that there is an ERA, that would only also further bolster the level of scrutiny, the way that courts analyze sex discrimination under the Constitution. So these are things that would certainly be helpful to sort of add on to the protections that the Supreme Court enshrined on Monday.
Thank you, Asaf. The last question I have is, what is the policy focus for NCLR for the remainder of the year?
Do you want to start, Amy? You're on mute.
Sorry about that. That's a great question. And, we've been at the forefront for decades of seeking to establish that federal sex discrimination laws protect our community. And with a huge boost from Monday's decision, we'll continue to litigate those issues aggressively under Title IX, the Fair Housing Act, the Affordable Care Act, and we'll continue to fight to end conversion therapy, to keep LGBTQ youth out of juvenile detention and foster care. We're going to continue our litigation and our advocacy on behalf of LGBTQ prisoners and for people who are economically marginalized, who live in poverty or who are otherwise marginalized in our community. That's kind of NCLR's mission, to make sure that we are reaching the people who have the least access to attorneys and to legal care and cases. And so that has been and will continue to be our goal at NCLR as we move forward.
Thank you, Amy. And that brings us just past 1 o'clock, and I wanted to thank everyone for participating on this call today. As I mentioned, we will be sending out a recording of the call, and if you had questions that did not get answered or you felt like you want more information, please reach out to us and we'll get back to you about that. Thank you again so much for your time today and participating on this call. As donors, as friends, as allies, as partners in this work, you know what it takes to get this work done, and we are so happy that you choose to be here with us. So on behalf of NCLR, thank you so much and enjoy the rest of your day.
Thanks, everyone.